May it please, Your Lordship. Your Lordship, I beg to mention item number 8. It's fixed for hearing. I pray for the matter may come up after 2 weeks, Your Lordship.
8 and 9.
8 and 9, yes.
Why?
8, my lord, I am for the petition, my lord. I don't have any objection.
Yes. What is this case about?
This, my lord, is regarding the election of Emily, my lord. So, matter was referred to the tribunal.
Okay.
Then after that, our petition was dismissed on the ground that they don't have the power to condone, my lord.
Okay. Oh, that.
Yes, yes, my lord. So, another matter is connected, my lord, item number 9.
Yes, Your Lordship.
Item number 9 is on suspension or?
No, not suspension, my lord. 9's also, they have filed some election petition only, my lord. But other group are filing, my lord.
Okay, okay.
Yes. There, in fact, they allowed, and that's why this petitioner in item number 9 has challenged why they have allowed. My lord.
Oh, well, your case is the
They have not allowed, my lord.
converse
Yes, yes, my
situation.
lord.
Okay. 8. How long?
I'm for respondent 1, 2, 3, and 5, Your Lordship.
2 weeks.
2 weeks, yes, Your Lordship.
2 weeks.
Yes.
9. Same. 9. 2 weeks.
Highly obliged, Your Lordship.
If it may please your lordship, I would like to speak about item number 7. The conducting counsel is unable to appear today as he is out of station, so the matter may be taken up anytime next week, preferably on Monday or Tuesday, my lord.
Okay. After 1 week.
Item number 1.
Please, Your Lordship. Yes, Mrs.
My lord,
So,
we have completed my argument on the last occasion, and I file also the written argument also in the written form. The other side should do continue their argument today.
yes.
Yes, ma'am. Well, I'm appearing for respondent number 4, madam.
Yes, please.
My lord, the present writ petition has been filed, my lord. If I may just take a lordship to the prayer in the writ petition, my lord.
Yes.
At page 7, in the premises so and so, on the next page, my lord.
Yes.
Mandamus directing them to clear and pay the outstanding amount bill of the petitioner totaling 4 crore 8 lakh so and so, along with an interest of 18% with effect from 1st January 2013 in respect of final work order number so and so, dated so and so, completed and executed by the petitioner so and so. So, well, basically, this is a money suit, my lord, for a direction to pay. According to them, the bills have not been paid, my lord. Now, my lord, whether a writ petition is maintainable for payment of money, my lord, there's a clear civil remedy provided for that, is if I go and file a money suit. And what is more glaring, my lord, if lordship kindly see, in the writ petition, my lord, para 3, if I may take a lordship, para 2 and 3, my lord.
Yes.
It's admitted position, my lord. If I may just read para 2.
Yes. Please.
Para 2, my lord. That the petitioner states that in the year 2008, the respondent number 1 had floated a tender by way of notice competitive bidding, calling upon the interested contractors, companies, firms, etc. to participate in the building for construction of RCC bridge number 166/5, balance work including bridge number 166/4 within approach along with the approaches on NH 62 in South Garo Hills, Meghalaya. And in response thereto, the petitioner submitted his bid and participated in the bidding process. And on being successful, the petitioner was awarded the contract wide final work order number so and so dated 24/7/2008. Para 3, my lord, that the petitioner states that in terms of the letter of award dated 24/6/2008, the petitioner executed, performed, and completed the work in the year 2013. To the complete satisfaction of the respondent department, and the same was accordingly intimated to the office of the respondent department. So, my lord, this is an admitted position. The petitioner themselves are saying the work was awarded to them in 2008. They completed the work in 2013, my lord. And this writ petition is filed in the year 2022, my lord, after a lapse of 9 years after that. Now, in my humble submission, this is clearly an attempt to circumvent the limitation period. For filing a civil suit, my lord, money suit, the limitation period is 3 years. They've come before this honorable court by way of writ petition after 9 years of arising of cause of action. admitting that cause of action arose in 2013 when they completed the work. So that is one aspect of the matter, and we have raised, my lord, that writ petition is not maintainable in this kind of dispute. This is in the domain of contextual rights and liabilities, and the proper remedy for them, if any, my lord, is to go and file a civil suit. Writ jurisdiction cannot be invoked. Secondly, my lord, the matter involves disputed questions of fact. Whether this honorable court can go into this aspect, that whether the bills, he has completed the work, he has not completed the work, whether how much amount he is entitled to, that is the second aspect, my lord. This honorable court in exercise of 226 will not go into the disputed questions of fact. So these are the preliminary objections, my lord, as to the very maintainability of the writ petition. Now, my lord, if I may take your lordship to our affidavit, my lord, of respondent number 4.
Yes, this is
Respondent number 4.
yes.
Now, my lord, how Ministry of Road Transport, Government of India is into picture, my lord, as we place, because this is the work related to National Highway, my lord. And National Highway works are executed through the state PWD, my lord.
Okay.
Para 4, if I may just refer, my lord. That the development and maintenance of national highways in the country is being implemented by MORTH, Ministry of Road Transport and Highways, through its implementing agencies, which that is National Highway Wing of State PWD, National Highway Authority of India, National Highways Infrastructure Development Corporation, and Border Roads Organization. Now, this work was maintained through the state National Highway Wing of the state PWD. Well, that's why state government is also party. Para 5, the implementing agencies carried out all activities related to development and maintenance of national highway as per their delegated power of MOST guidelines. The implementing agencies are paid a fee in the form of agency charges for all activities of preparation of DPR, getting pre-construction activities, clearance, and so basically that is the issue, my lord. Though it is central project, my lord, it is implemented through the state PWD. There is a national highway wing of the state PWD, my lord. Now, para 6, my lord. The factual position we have asserted.
Yes.
The MORTH has taken up the project mentioned reconstruction of RCC bridge number so and so, balance work including bridge number so and so along the approaches of National Highway 62 in the South Garo Hills, and which was sanctioned by MORTH by job number so and so on 31/3/2008. That the project was awarded to Upendranath Saha, the petitioner, while letter number so and so dated 24/7/2008 for a tender value of rupees 4 crore 87 lakhs, so with a timeline of 24 months for completion. The work was completed on 30/6/2013 after a delay of more than 3 years. That upon completion of the work as per the provision mentioned in the contract agreement, payment for an amount of rupees 4 crores has been made to the petitioner through various running account bills. Now, my lord, kindly see, contract value was 4 crore 87 lakh rupees, my lord. 4 crore 47 lakh has already been paid to them.
Mr. Sahu, you are admitting this?
Yes, my lord, actually this contract was subsequently amended. Thereafter this amended, and after amendment there is a proposal has been given by the state department, state PW to the central. Till then that is no approval or order, that is an internal matter. Meanwhile, I completed the project as per the requirement of the tender. I handed over the project to the department. Department also utilized in the public purpose. Thereafter no communication, nothing, no correspondence. I have given 17 numbers of correspondence.
Fine, fine.
No dispute has been raised.
We are only on the facts.
Yes.
Only on the facts, my lord.
So
Yes. Let him continue.
You can reply to it. So, my lord, what I'm submitting is out of 4 crore 87 lakh rupees, my lord, 4 crore 47 lakh has already been paid to him. Now, I'll continue reading. My lord. The work executed by the petitioner was more than the quantities specified in the bill of quantities and the variation in statement which is to be approved by the competent authority of the month. For item of work which are beyond the bills of quantity as per contract agreement, an amount of rupees 74 lakh rupees was withheld from the 6th running bill account bill after restricting the total quantity as per the contract agreement. A letter was submitted to the respondent number 3 for submitting a revised cost estimate for approval from the month. Further, it is to pertinent mention that as per the provision mentioned in the sanction letter, there was no provision for price escalation. The petitioner has submitted a bill for the price escalation amounting to rupees 71 lakh and rupees 67 lakh to the respondent number 3. However, the same was not received by the respondent number 4 and hence no correspondence regarding payment could be made to the petitioner. Further, it is to be mentioned that the cost of price escalation was invariably high due to delay of more than 3 years on the part of the petitioner for completion of the project. It is the responsibility of the respondent number 2 and 3 to take advanced action to ascertain the requirement of item so and so, so and so. So, my lord, the factual position as it stands, my lord, out of 487, 447 has already been paid. Now even the 487 bill which they presented, my lord, there was dispute as to the quantity of work, my lord. Lordship, in the bill of quantity means how much cement is to be required, how much steel is required, and how much sand and all these things. There was a variation in that. And their price escalation bill is also only 71 lakh rupees and 67 lakh rupees, my lord. You'll also have seen that in para 9. Now the 71 lakh and 67 lakh, we are saying that there is no price escalation clause in the, because lordship, what happens, lordship is seen in the contract agreement. If there is a delay in the work, my lord, the prices of material goes up. So in some contract there is a agreement. Now it has to be examined, delay is because of whose fault. If the department's fault, my lord, maybe sometimes they are liable to.
So there's a provision for revised costs.
In this contract, there is none, my lord. In para 9, that is what it starts. It says that further it is pertinent to mention that as per the provisions mentioned in the sanction letter, there was no provision for price escalation. There is no provision, my lord. They are claiming price escalation. Now this dispute, my lord, is a civil dispute, my lord. Whether there was a price escalation clause or not, whether we are liable, and if we are liable, how much? What was the price escalation?
There's no arbitration clause.
It appears there is no arbitration clause.
Yes, madam, we have submitted the document.
The arbitration clause is there.
We have a senior counsel who has present state, Mr. Shubha has also raised the documents pertaining to tender manner that the petitioner will be submitted to a court member, and the petitioner has not appealed that arbitration clause. We have submitted it.
It's too late for arbitration also. Same limitation for arbitration also.
Yeah, not, yes. Initially.
Yes, my lord, there was arbitration clause.
Yes.
So, my lord, this involves a very disputed question of fact, my lord. 76 lakh, 71 lakh and 67 lakh rupees were the original amount which they are claiming on account of escalation, my lord. Now we are saying there is no escalation clause. Now 71 plus 67 at the most will become 130, 140. The prayer is for 4 crore 4 lakh rupees, my lord. Now for this honorable court to go into these example questions, my lord, at such belated stage, when clearly it's a time bar. 3 years is the clear limitation period, my lord, for any recovery of money. So that is our plea, my lord, that petition is not maintainable. This honorable court cannot go into disputed questions of fact. They had civil remedy, my lord, either by way of arbitration or by way of filing a commercial suit. Nowadays, the commercial courts, my lord. At this stage also, if they can, but there is no provision for condonation of delay in the original suit, my lord. So at this stage, no relief is permissible, my lord, to them. That is our simple case, my lord. Now they will annex some correspondences and will not extend the limitation with that settled law. Delay of 9 years. We hadn't been delay of 1 or 2 months, 6 months, my lord. After completing, they admit that the work was completed in 2013. Writ petition is filed in 2022, my lord.
But as far as exchange of correspondence is concerned, that period has to be taken into.
No, my lord. In original money suit, my lord, there is no provision for condonation. Lords, you have come across so many arbitration matters. Condonation will only come if there is a provision for empowering the court to condone the delay, my lord. But our case before your lordship is that they cannot circumvent the civil court, my lord, or they cannot circumvent arbitration, whatever available to them. To circumvent limitation, my lord, they've come before this honorable court by way of 226, which is not permissible, my lord. If they have any remedy available to them as per law, they can pursue that, my lord.
In other words, you are saying that they have approached the wrong forum,
They approach the wrong forum, and that also very belated, my lord.
deleted.
My lord.
Anything else?
And the amounts are very, very disputed, my lord. As I pointed out, their escalation bill, now whether escalation clause is there or not, the lordship cannot examine that, my lord. If it is there, how much should be the escalation? They are saying the cement price increased by, during that period, from 8 to 13 increased by, now how much percent? There is no document available before us on the record, my lord, to come to a conclusion that how much cement was used actually, whether it was 100 rupees, the price became 120 rupees. For this honorable court to do that kind of calculation also is not permissible, my lord, under its jurisdiction. That is our case, my lord. The state is represented by Mr. Chulai.
From next month, this matters. Madam, I kindly reserve our submission till tomorrow, madam. Because this lordship has already heard. Oh, my lord, and of the board, my lord, because senior counsel has already argued. Because we are standing on the same footing, my lord. Our objections are more or less the same, my lord.
It is not a case that no amount has been paid, my lord. Substantial, more than 90% amount has been paid to them.
What do we do?
My lord, actually,
Mr. Shulai is not here, so
let him file the written argument, written form, then I will continue my
file their written argument after. See, the parties will be called upon to file. You have filed your written argument.
Yes.
They will file, but parties have to be heard. I mean,
My lord, here actually, this after the prayer, my prayer is only to issue necessary direction to the department to make arrangement of the payment, not quantification of the amount. I am not here before your lordship for quantification, the dispute, nothing, because there is no dispute on record. Whatever dispute from there, they are telling from their own, but I have never been made a party before them. What is the dispute? If I will file the substantially abstention clause regarding the escalation clause, but if there had there been any dispute on that, they should have made a party, or they to come to for us to place your documents, how, under what basis you done. They have not done anything. If they would have done, so this situation has not been here. Here at this stage, there is no scope to approach the civil court because there is no dispute yet around. My lord, friends could not file any document where is the dispute. There is no arbitration clause. If that is no arbitration clause or the escalation clause, so they should, the department, whenever I am making my bills, they should state your bills has been rejected on this ground. No mention is there, no reconciliation is there, no action has been initiated. So at this stage, I am giving my reply, sending my reply and requesting to clear my dues. They are not doing. So the government, being a government authority, they should fair play to their citizens. If this will happen, so the faith will be removed from the mind of the citizens, the public, so nobody will come up. So showing the technical ground, if will swallow all the monies in this way or forfeit the money, so that will be a great mishap to the sovereign government. They cannot do in this way. Whatever event there is, I have committed a mistake, so they should first come and you sit here. This is you quantify the amount and you clear the bills. This is your legitimate bill, and I paid this and I withhold this. They have not done this. So under which how can I go approach to the civil court? On what basis I will go? What is the evidence with me? Nothing, only simply a contract. Nothing more than that with me. But I have utilized the fund. I utilize my manpower. I have utilized my time. Thereafter, I complete all this. There is no objection. You accepted the project. Thereafter, now telling that it's a time bar. Why is there a time bar? There should not be any time bar because there is being a government authority, they should fair play. So whatever, if they are intentionally or without any intention, what they are doing, they are liable to pay all these things along with the interest, along with the compensatory exemplary cost also. I know. My in my last written argument, I have given Article 220 can be invoked when there is a illegality.
Honestly, that is.
There is a settlement. So many laws are there which the Supreme Court settled, and I filed also the certain High Court's rulings, Karnataka High Court, Kerala High Court, Jammu and Kashmir High Court, and Supreme Court also they said. Those say other even arbitration clause is there. In that case, also Article 220 can be when there is a illegality.
My lord, may I draw one just to counter? You will also kindly take a writ petition, my lord. Para 4 of the writ petition. Kindly see, my lord. Kindly see the pleading, my lord. Total suppression of fact also.
Yes.
Para 4, my lord, that the petitioner state the total bill amount raised and submitted for the contract work to the respondent is rupees 4 crore 8 lakh rupees. In our affidavit, we have said, now they admit, my lord,
No.
that total contract was 4 crore 87 lakh rupees, 4 crore 47 lakh paid to them. They have not disclosed anywhere, my lord.
No,
Kindly see the writ petition, my lord.
this is
They are saying that their bill of 4 crore 8 lakh rupees was never paid. No amount has been paid. Kindly see the entire paragraph, entire writ petition is framed on that, my lord. They are saying that they submitted total bill of 4 crore 8 lakh rupees and no amount has been paid till now.
4 crore 8 lakhs is receivable from them. 4 crore 8 lakhs.
Para 4, my lord. State the total bill amount raised and submitted for the contract work to the respondent is rupees 4 crore 8 lakh rupees. And the same was not disputed by the respondent department.
They have not
They have not disclosed that 4 crore 87 lakh was the bill. 447 is already paid to them. So the dispute, if any, is 40 lakh rupees or 67 lakh rupees. State with their pleading is altogether different.
No, my lord. Subsequently,
Yes,
initially,
because you see, this the wordings in this paragraph is very vague. You have only stated about the bill raised. Never said about whether it was, whether it was paid to you, not paid, how much paid.
here actually I mentioned total value of the contract. Initially, it was 4 crore 87 lakhs 30,500. Thereafter, that has been enhanced by another contract number by letter reference of PWTB BR 46 2005-18, dated Shillong 18 May 2011.
Where is that?
In my written argument, I have mentioned the number, and I have also mentioned the document also here there. In also petition also there.
Should be in the petition.
Yes.
Where is it?
Yes, I am.
There is no pleading. Petition.
18 dated 18/5/11.
See, Mr. Sahu,
Yes, my lord.
even at para 9,
Yeah.
you have said yes. This amount of 4 crores 8 lakhs have not been paid to you,
Yes.
and you have taken steps to issue notice,
Yes.
legal notice.
Yes.
So, you see, if you have taken steps to issue legal notice, then what follows? If it is not complied with, not responded to, then the next step should have been for you to approach the civil courts. But you have not done that.
But the bills has been raised on them. The bills has been filed with the respondents.
That's true.
Yes.
True. That's
My
true.
lord, actually, I have the bona fide impression that state government should not do in this way. I have the bona fide impression that I have completed. There is no.
See, Mr. Sahu, you know very well. I don't have to tell you.
So, state government should not in this
as Dr. Muzika said, the process is very simple. You have made certain demands, irrespective of the amount. We are not talking about the amount. Could be X, Y, Z, whatever. And the corresponding authorities are to satisfy that.
Yes.
They have to pay you that amount. They have not paid. You have, issued notice, maybe written to them.
They have not
They
responded.
have not responded.
They did not respond.
It is, you see, when it comes to money matters, you should have you should have approached the civil court. You cannot.
So,
I
my
don't
lord,
think-
actually, this is a bona fide impression I have that on that basis I am waiting for them.
that cannot
They-
be.
Let them complete my bill sense of these things.
It has to be in accordance with law. What does the law prescribes? What course of action you have to take? for your demand to be satisfied, but you have not done.
Yes, actually, I have tried my level best to settle all these things before that, but whenever, unless until they will raise any objection on that, I am helpless to go for any further.
No,
And
I think
this honorable court has the jurisdiction
maybe
because
I
there
don't
is
think
when there is my simplicity to
And
necessary
the-
direction.
The point is very clear. See, the High Court would not enter into any matter where there's a disputed, very serious dispute as far as facts are concerned. If it is disputed question, then
But there is no dispute here, my lord.
and-
They have not filed any objection or the documentary objection on
the
this.
dispute here is with regard to the amounts claim, as has been pointed out.
But there is any dispute on that. They are keeping silent.
Anyway,
So, my lord, keeping in view this honorable court has the jurisdiction to only to issue necessary direction. Let me clear at their stand to settle the dues first. I have no objection on that. Let them start for clearing the settlement of the dues. If anything is payable to me, then I will be entitled to. If I am not entitled to receive that, I will forego that. I have no objection on that. My humble subject to issue necessary direction to the other sides.
but have you received anything so far?
Whatever bills I have submitted, I have not received. Only a part of the bill I have.
That 4 crores 47
Yeah,
lakhs you have not received.
Yes, I have mentioned. I have mentioned 4 crore 38 47 396 have received.
Received.
Out of this 7 crore,
Exactly.
7 crore 57,
Exactly.
54.
Exactly.
Total
So-
program
so
project
again-
is 7 crore 54.
So again, you see, it's a question of dispute as to the amount that is due and payable to you.
Yes. So remaining 4 crores, near about 4 crores, that is to be, but they are not taking any action on that, my lord. That is my humble submission before lordship.
We are
Let them have necessary direction to
Mr.
settle their dues, whatever is payable, receivable.
Since 2022, we are wasting time on this.
My lord, I have not taken any time back. The other side, they are taking time.
As far as this period is concerned, maybe
And-
condonation for that would be there.
They're entitled to Section 14, my lord, Limitation Act.
But anyway,
Actually, my lord, this court should be taken in.
but Mr. Shulai should be here. At least, so the court should hear him.
The other matter, I've already paid for time for having it at the end of the court.
Yeah,
So
but
I believe Mr. Shulai will definitely come for that matter. So, or otherwise tomorrow, my lord, we can conclude it.
you'll be here tomorrow.
My lord?
You'll be here tomorrow.
Yes, I can. I will be available.
So we'll continue tomorrow.
Yes, no problem.
Second matter, the connected matter also similar. my
Similar
lord.
issue,
The
yes.
date of contract is different, the amount is different. my lord.
Tomorrow.
More or less similar. my lord.
Heard Dr. Musira, Direct Counsel for the respondent 4 and 5.
Four.
4 or 5?
4.
Respondent 4.
The 4 response only.
As prayed for by parties, this is matter for further hearing. Tomorrow.
So,
The next item is still.
Yeah, right. Deep.
Item number 6.
State का है भाई.
Okay, straight.
Very good state in this matter. Wait, please, Your Lordships. Well, this pertains to minutes the constitution of the WAF Board of Meghalaya minutes.
Yes.
Millets, the constitution millets was notified by the state of Meghalaya by an order dated the 5th of January 2023, which my lords would find at page 23 of my writ petition. State is important. No?
Page.
Page 23, my lords. I can begin, but the only thing is Mr. Kharmi, who's representing the state, is not here. So once I start, my lords, it should not be one of those exercises.
Who's
Just find out
If
if
I
Mr.
can-
Kharmi is there.
If I can humbly suggest, my friend can start. I'll reply. In the meantime, I'm sure Mr. Kharmi will join. He was looking forward to this hearing, so I'm sure he's ready for that. I've sent somebody to look for him.
And let me just continue for the time being, my lords. We'll just find out.
Because I think this would be, the issue would be as far as the action of the state,
Action of the state, my lords.
Notification issued by state.
Is it?
Yes.
Notification for the
Constitution, my lords.
constitution and the
It's issued by the state.
But the person affected is me.
you
my
can
lords.
start and we'll see.
Yes, my lords. My lords, at page 23, my lords would see this is, my lords, the order dated 5th of January 2023.
Yes.
Now, my lords, before I come to this order, first I'll take your lordships to section 14 of the WAF Act. There's a WAF Act of 1995, my lords. My lords, can I have a look at section 14?
14.
14, my lords, 1-4.
Yes.
Composition of board. The board for a state and, well, it's not relevant, National Capital Territory of Delhi shall consist of.
Yes.
What? He is not here. You look here. Let's, I am informed Mr. Kharmi is not here.
Who?
Mr. Kharmi, my lords, who is appearing for the state, he is not here. That's what I am informed. I think Mr. Ibrahim is here, my lords, for the state.
Because I wouldn't be able to access the court. So if this matter may be taken up,
We'll start. Let's see. Like you will not have much as far as the state is concerned.
That's
You just have to defend your action of issuing of the
notification.
notification, whether it was done in accordance with law, so on and so forth.
Well, as the board of a state shall consist of A. a chairperson, B. millets, one and not more than two members of the state as the state government may think fit to be elected from each of the electoral colleges consisting of. Millets, I would request my lords to kindly take note of B.
Yes.
This is where the dispute, millets, originates from. Now, millets, the electoral college will consist of, millets, 1. Muslim members of parliament from the state, or as the case may be, the National Capital Territory of Delhi, not relevant. Muslim members of the state legislature. Number 3, millets, Muslim members of the Bar Council of the concerned state or union territory, provided that in case there is no Muslim member of the Bar Council of a state or a union territory, the state government or the union territory administration, as the case may be, may nominate any senior Muslim advocate from the state or union territory. Then 4, millets, Mutawlis of a WAF having an annual income of rupees 1 lakh and above. Explanation: for the removal of doubts, it is hereby declared that the members of the categories mentioned above in subclauses 1 to 4 shall be elected from the electoral college constituted for each category. Explanation 2: for the removal of doubts, it is hereby declared that in case a Muslim member ceases to be a Muslim member of parliament, not relevant for our purposes. But then, of course, my lords, your lordships may come to C. One person from amongst Muslims who has professional experience in town planning or business management, social work, finance or revenue, agriculture and development activities to be nominated by the state government. D. One person each from amongst Muslims nominated by the state government from recognized scholars in Shia and Sunni Islamic ideology. E. One person from amongst Muslims to be nominated by the state government from amongst the officers of the state government not below the rank of joint secretary to the state government. Your lordships may then kindly have a look. Subsection 2, my lords, is not relevant for our purposes. I'll come straight to subsection 3. My lords, may I kindly have subsection 3.
Yes.
Notwithstanding anything contained in this section, where the state government is satisfied for the reasons to be recorded in writing that it is not reasonably practicable to constitute an electoral college for any of the categories mentioned in subclauses 1 to 3 of clause B of subsection 1, the state government may nominate such persons as members of the board as it deems fit. So, Millets, the position of law as I understand it is, Millets, that under subsection 1, an electoral college is to be formed, Millets, of Muslim MPs, and Millets, number 2 would be Muslim MLAs. Number 3, Millets, will be Muslim members of the Bar Council of the state.
These electoral, the electoral college
Millets.
would be for different
Categories.
Different categories.
Categories, Millets. And then they would elect Millets from each category. So, Millets, the admitted position is that insofar as I'll take your lordships to the impugned order at page 23 now.
Yes.
Now, it says, in exercise of the powers conferred by subsection 1 of section 13 of the WAF Act 1995 as amended, the Governor of Meghalaya is pleased to reconstitute the Meghalaya Board of WAF with effect from the date of its publication in the official gazette. Whereas some members of the Meghalaya Board of WAF to be appointed from amongst the Muslim MPs and Muslim MLAs, the Muslim Bar Council members and the mutawallis of certain WAFs are to be elected by the Electoral College of their respective categories. And whereas there are no Muslim MPs or MLAs from the state, number 2, there are only 2 Muslim MLAs in the state assembly. Number 3, the Muslim advocates of the Bar Association have, however, agreed to co-opt members from amongst them to be members of the Bar Council, Meghalaya Board of WAF. My lords may kindly take note of this. C. And whereas the state government is thus satisfied that it is not practicable to constitute the respective electoral colleges for the purposes envisaged, it should be, hence resorted to the provisions of subsection 3 of section 14 of the aforesaid Act. Now, therefore, in exercise of the powers conferred under section 14 of the Act and all enabling provisions on that behalf, the Governor of Meghalaya hereby nominates and appoints the following persons to be members of the Meghalaya Board of WAF, namely, then that's serial number 1 and 2 are the 2 Muslim MLAs of the state. Then at serial number 3, is 1 Janab Asghar Siddiqui, Advocate Bar Council. Then at 4 is Mrs. Roshanara Begum, Advocate Social Activist. And they are appointed against this category, Muslim member of the Bar Council, Muslim member of the Bar Council. Then there is, against the category of Mutawli, we have somebody Janab Ahmed Hussain. Then, at serial number 6, we have Muhammad Zahir, Secretary Muslim Socio-Cultural and Educational Association. He is appointed against the category of Muslim Professional Experience in Town Planning and Business Management and Social Welfare, Finance and Revenue Agriculture Development. Then, Noor Muhammad Shah is the Muslim scholar. Janab Mustafiq Uddin Ahmed is the Muslim officer of the state government. Mrs. Nooreen Mehraj Wajri, woman member. And Roshanara Begum, again, woman member of the board. Now, the plea that is taken by the state is, they say...
Is 4 and 10 the same person?
4 and 10 was same, so there was a corrigendum that was published, and the name was changed. That would find, would find at Annexure 2, page 25. In partial modification to this department's notification number so-and-so, the Governor of Meghalaya hereby nominate and appoint Shri Shehnaz Abbas, Advocate and Women Member of the Meghalaya Board of WAF under section 14(1)(c) of the Meghalaya Board of WAF 99 as amended in place of Roshanara Begum. So Roshanara Begum's name was coming twice, so that was substituted by the name of Shehnaz Abbas.
Yes.
Now, insofar as the issue here is concerned is, and I draw your lordship's attention again to page 23, The first issue is, my lords, that insofar as MPs are concerned, there are no MPs. Fair enough. Then, my lords, insofar as two Muslim MLAs are concerned, my lords, under the second category, two Muslim MLAs have been nominated. Now, in the third category, my lords, may kindly see, the Muslim advocates of the Bar Association have, however, agreed to co-opt members from amongst themselves to be members of the Meghalaya Board of WAF. Now, the requirement of law is, my lords, it says the proviso to subsection 1A, 1B is, my lords, provided that in case there are no Muslim members of the Bar Council of a state or a union territory, the state government or the union territory administration, as the case may be, may nominate any senior Muslim advocate from the state of the union territory. So the question of co-option, my lords, in the first place doesn't come. It cannot be, my lords, that we decide amongst ourselves that who will be nominated. So if the power is to be exercised even under subsection 3, in the event of unavailability of, my lords, any member of the Bar Council, then that power has to be exercised in a manner which is prescribed under section 14, subsection 1B, the proviso thereto. Now the state says, my lords, in its affidavit, draw your lordship's attention to paragraph 4.
So your grievance is to the inclusion of this name.
I am, my lords, on the inclusion of these two members, my lords, as Muslim members of the Bar Council. 3, 4. 6, my lords, because we say he does not have the requisite qualifications. So it will essentially be with regard to 3, 4 and 6. Insofar as, my lords, 7, 8, 9, 10 are concerned, show me those two orders.
See, so what comes out from here is that there was no, rather the authorities or the government for that matter have not followed the procedure laid down in
14.1.
14.1.
My lords. Because 14.1 also provides that in case it is not available, then what is the procedure to be followed? That procedure, my lords, cannot be dehorsed what is envisaged under the Act. 14.3 provides that if the Electoral College is not available under 14.1, then, my lords, we will have to resort to 14.3. The power shifts onto the government, that government may nominate. Now, the government is saying, my lords, the nomination is on the basis of some arrangement that was there between the Muslim members of the Bar Association. A, my lords, the affidavit does not disclose what was the arrangement. B, even if there was an arrangement, whether that arrangement could have been, my lords, the substance or the basis of the nomination to be made by the government under subsection 3. That is the case that I put, that's the question, my lords, that I seem to formulate before, my lords. Okay. The other, of course, my lords, is insofar as respondent number 6 and the other respondents, it was a general statement with regard to all the respondents. We say that they do not possess the requisite qualifications of being nominated by the government against that respective category.
So, but they would also have to be included, through
no, in respect of them, my lords, the Electoral College does not come into play.
So that is what I said.
They are only against certain categories. So, my lords, if I can explain, the first is, my lords, the MPs, then the MLAs, then the members of the Bar Council, then the Mutawallis.
Yes.
That is under subsection 1A, my lords.
Yes, 1A.
So, in respect of them, my lords, there has to be an Electoral College, and amongst them, there has to be elections. In respect of the others, my lords, the category of professionals, my lords, then a scholar, officer of the government, woman member. Now, these, my lords, would essentially have to be nominated by the government. Now, we say, my lords, that they do not possess the requisite qualifications to be nominated by the government as against that particular category. So, the government, my lords, just makes a sweeping statement saying that we deny that and we put it to challenge. That is all. They do not say under why this nomination was available and under what circumstances, my lords, the nomination was made by the state. Insofar as the first issue is concerned, my lords, with regard to the...
so there are no guidelines as such, or...
That would be for the state to then suggest.
No SOP, nothing?
That nothing is on record. What is on record, my lords, and I can point it out for respondent number 6. Now, the state says, there were 3 suggestions for these particular categories, the reconstitution. And they have brought that out. I'll just take your lordships to the relevant paragraph first.
And who's to suggest? The community?
Community, it has to be from the community.
Through what platform?
These the 3 suggestions that were made. These were under one was by the outgoing Board of WAF. This first suggestion was made by the Meghalaya State Board of WAF, the outgoing Board of WAF. The second was made by one Nuren Mehraj Wajri, who was a member of the State Board of WAF. And the third was made by A.M. Qureshi. He does not say anything about what is his thing. I think some general objections are called, and on the basis of that, these suggestions are taken. I'll just take a lordship to the relevant paragraph. Para 9, at page 5. Para 9, of the state affidavit. This filed by one Shri Paveen Bakshi. The para 7 would be relevant, I'm sorry. At page 3, para 7.
Yes.
May I read, para 7? That with regard to the averments made by at paragraph 4 of the writ petition, the answering respondent submits that all the provisions under section 14 of the WAF Act have been followed, and at every stage the views of the law department were taken before the reconstitution of the Meghalaya State Board WAF, whose last 5-year term expired on 15/3/2022 upon completion of the term. The state government was in receipt of 3 independent proposals from the Chief Executive Officer Meghalaya State Board of WAF, Srimati Nuren Mehraj Wajri and Dr. A.M. Qureshi, and further was in receipt of several complaints and counter-complaints related to individuals who were named in the proposal. Apart from the above, there were cases in the Honorable High Court of Meghalaya which made in the process of selection sub judice. Accordingly, only after preparing comparative statements of all the 3 proposals and approval by the Minister of So-and-so and duly vetted by the Law Department of Government of Meghalaya, the notification number so-and-so reconstituting the Meghalaya Board of WAF was issued. The answering respondent would like to submit that on so-and-so a petition was received by the respondent bringing on light the name that Roshanara Begum, activist and social, mentioned 2 times. That I've taken your lordships, how the corrigendum comes to be. Okay. So now what were the proposals, my lords? May kindly have a look. Well, the first proposal is at page 10.
Yes.
Well, this is from the Meghalaya State Board of WAF. It says it is from so-and-so Mellods to Deputy Secretary Government of Meghalaya. With reference to the above subject cited subject, as per notification under reference, this to inform you that the existing Board of Meghalaya State Board of WAF will be completing its tenure on the 16th of March 2022. The notification of the Board of Members was made on 16 March 2017 for a period of 5 years. It is therefore requested to reconstitute the Board for a period of 5 years with members selected and so-and-so copy enclosed as per section 14, 15, 16 provided the provisions of the WAF Act 1995 for selection of members of the board. This enclosed list has the approval of the chairman for better and smooth functioning of the board. Now the list of suggested members, my lords, if my lords kindly come. The first is the 2 MLAs, my lords. Of course, there is no dispute with that. At that point of time, they were just those 2 MLAs. Then, my lords, Parveen Ahmed, advocate member of the Bar Council of Women, may be constituted under section 14(b)(3) and 14(e) of the WAF Act of 1995. Janab Khalid Khan, advocate member of Bar Council, may be considered as per section 14(b)(3) of the WAF Act. Janab Muhammad Zakaria, joint Mutawalli of Haji Ilahi Baksh WAF Estate, may be considered as per section 14. Janab Sajjad Uddin Ahmed, retired Secretary PW to the Government of Meghalaya, may be a member of the State Bar as may be considered under 14C of the WAF Act. Fozibur Rahman, ex-MDC, Fulbari constituency, another member taken for consideration under 14C of the WAF Act. Joshimuddin Ahmed, being a businessman, may be considered as per 14C of the WAF Act. Bilkish Mondol, being a woman member and secretary of a madrasa, may be considered under 14C and 14E. Janab Abdul Sultan, being a businessman, may be considered under section 14C of the WAF Act. Maulana Rafiquddin Khan Kismi, Imam of Lamukra Mosque, who is an alim with a degree certificate in Fazl, may be considered as 14D of the WAF Act. Mustafiquddin Ahmed, Chief Engineer so-and-so, may be considered under 14E of the WAF Act. And my lords, under what category? That is given at page 12. Then, my lords, the second proposal, your lordships would find at page 13. So again, and serial number 1 and 2, my lords, there is no problem because they are the only two MLAs. Mohammad Zahir, Secretary, Muslim Socio-Cultural and Educational Association. Afzal Hussain, Ahmad Usef, Asghar Siddiqui, Nuren Warjari, Wahid Nongbri, Mohammad Shan Rahman, Roshanara Begum, my lords. These were the names that were suggested. And the last suggestion is at page 14, my lords. Against B, they say, my lords, B2, Muslim members of the Meghalaya Legislative Assembly, Abdul Saleh, Istamar Sonso, Senior Muslim Advocate of the High Court of Meghalaya, Shri A. Siddiqui. Then Mutawali of the WAF, Mohammad Zakaria, Joint Mutawali, Haji Lai WAF Estate, Sara Khonkorkor, BLLB members, so-and-so, Maulana Rafiquddin Navbi, Lai Mukhra Mosque. It is therefore requested the above proposal may be considered for the effective functioning of the board. Then, my lords, is the impugned order. So, my lords, again coming back to the affidavit of the state. This is so, my lords, at paragraph 8, they say that since, my lords, the requirements of holding the electoral college in section 14.1 was not available, therefore recourse was taken to subsection 3 of section 14. And, my lords, how it is done, they say in para 9, I'll read out para 9. With regard to the contentions raised in the paragraph 6 of the petition, the answering deponent wishes to state that the aforementioned petition was received by the respondent, but the nature of complaint were vague and general, not specifying how and why and whom in the newly constituted Meghalaya State Board of it was alleged that the required qualifications are not there. The Social Welfare Department, Government of Meghalaya, had in fact stated that the qualifications and designation of members also to ensure transparency and disclosure of identities and affiliations of members of the so selected by nominations. The modified notification, which was brought out on 13/1/2023, also has not violated any of the provisions of section 14 of the WAF Act of 1995, as no members had been removed, rather than the member replaced at serial number 10 had been replaced by Shanaz Abbas, as per the petition received from so-and-so, who had joined as a member of the so-and-so at the time of submitting the petition. Further, in the notification as per provisions of the WAF Act, already 2 members were there, which was increased to 3 with the appointment of Shanaz Abbas, indicating that the state government was progressive in its selection of women candidates for the post of members of the state WAF board. The answering respondent would also like to question the locus of the petitioner and also like to understand the petitioner has been affected by the notification. Would like to assert that the petitioner is merely making allegations because apparently members of his personal choice have not been selected. If further not explained which members' qualifications are not mixed amongst the members of the Meghalaya Student Board, it is again reiterated that the qualifications, affiliations as far as practicable have been already mentioned in the notification dated so and so. Now, we have to then essentially have to go back to the notification itself, my lords. The lordships will then see at serial number 3, my lords, at page 23.
Yes.
My lords, Asghar Siddiqui, Janab Asghar Siddiqui is shown as a Muslim member of the Bar Council. Roshanara Begum, my lords, is again mentioned as an advocate, social activist, and appointed as against the Muslim members of the Bar Council. That, my lords, in my humble submission, is not permissible under law. Because admittedly, my lords, at that point of time especially, since now the Bar Council is not there, at that point of time, the Bar Council did not have, my lords, any Muslim members. So in the absence of any Muslim members, my lords, then the state would have to take recourse to the proviso as provided under subsection C of section 14(1), which then provides, my lords, that the nomination would have to be amongst the senior Muslim advocate. The expression is used as senior Muslim advocate. The second, my lords, insofar as Mohammad Zahir is concerned, my lords, who's appointed against the category of Muslim professional expertise in town planning or business, management, social work, finance or revenue, agriculture, development, my lords, he simply says Mohammad Zahir, Secretary, Muslim Socio-Cultural and Educational Association. Of which association, how, when, nothing is mentioned. The state, my lords, in its affidavit would essentially have to disclose that the requirements of law have been considered by them to the extent possible. And, my lords, thereafter the nominations have been made. Same with regard to, my lords, the other three candidates, that is 7 and 8. Insofar as women members are concerned, my lords, because both are ladies, so therefore I don't think there's too much to be questioned on that.
Okay.
Now, my lords, insofar as the private respondent is concerned, my lords, their notice has been served on all of them. My learned friend initially entered appearance on behalf of, my lords, respondent number 7, 8, 9, 10, 13 and 14. And that would be reflective from order dated 26/9/2023. And, my lords, he says that only the affidavit filed by respondent number 10 would suffice insofar as all the respondents are concerned. Now, therefore, my lords, I take your lordships to the affidavit filed by respondent number 10. So in my writ petition, my lords, just one aspect I'll have to highlight over here. In my para 9, if my lords kindly have a look at page 16, writ petition, para 9.
Yes.
Well, as we say that the petitioner submits that for constitution of the WAF board, the respondents are required to strictly adhere to the mandatory provisions of section 14 of the new act. It is submitted that the instant case the respondents admittedly constitute a new board which comprises of members who do not possess the requisite eligibility criteria qualification prescribed under section 14 of the new act. Therefore, essentially deviating from the statutory provisions of section 14 of the new act. As such, the impugned notification being illegal, arbitrary and perverse is liable to be quashed and set aside. But this challenges, my lords, the eligibility of the respondents. Now, the answer to that, my lords, in the affidavit filed by the private respondent would be available at paragraph 10. At page 7, my lords.
This one.
That in response to the contents of para 9 of the writ. I'm sorry, my lords.
Para 10.
Para 10, my lords.
Yes. Please.
That in response to the contents of para 9 of the writ petition, it is humbly pointed out that the same reflect very clearly that the challenge being raised by the petitioners amongst the reconstitution of the board is purely on the ground of criteria, qualifications as alleged, and the alleged absence of qualifications on the part of the present members. As brought out in para 3 above, the issue of qualifications or the absence thereof would have been relevant only if the board had been reconstituted under section 14(1) of the Act. However, in the present, reconstitution has been conducted under section 14(3) of the Act, where the presence absence of qualification as listed in 14(1) have no role to play. In any event, it is humbly pointed out the present members, including dependent, are upstanding members of Muslim society and cannot be considered as unfit in any manner for being nominated as members of the board. So they do not say, my lords, that they have the qualifications. What they essentially say is that the power is being exercised under section 14(3). So therefore, the criteria of whether I have the qualification or I do not have the qualification is no longer a requirement of law, since the board is being reconstituted under subsection 3 of section 14 and not under subsection 1 of section 14. Similarly, my lords, the state, it's affidavit. Oh, sorry. In para 16, my lords, they deal with para 16, para 9 of my affidavit, of my writ petition. Your lordships would find that at page 7.
Page 7?
Of the affidavit of the state, my lords.
Para 16.
16, my lords. They respond to my para 9 and para 16, my lords.
Yes.
That with regard to the averment made in para 9 of the petition, the answering deponent denies the contentions and submissions of the petitioner and reiterates that section 14 has been followed in the reconstitution of the Meghalaya State Board of Off, and the petitioner is neither an affected party nor can claim an affected party in this matter. Locus standi of the petitioner is unclear, and allegations to be personal and motivated to jeopardize the functioning of so-and-so. They do not say, my lords, in any manner whether, my lords, the qualifications are available or they are not available.
Yes.
So my humble submission is, my lords, that even, my lords, if the power has been exercised under subsection 3 of section 14, it cannot be literally on thin air. May not be in letter, my lords, but the spirit of section 14(1) will then have to apply. Because if I am appointing somebody against a certain category, my lords, maybe the electoral college is not there, so we cannot go for an election. But then my nomination, and as would be apparent from whatever I pointed out before your lordships, my lords, is on certain heads under certain categories, which is provided for in subsection 1. So if I am, my lords, then relying on a certain category under subsection 1, the manner of nomination by the state government would essentially have to be under the, my lords, provisions of subsection 1 and not dehorse the provisions of subsection 1. So therefore, my lords, to contend before this honorable court that the question of requirement, qualification or not having the qualification itself goes whence the power is exercised under subsection 3, my lords, in my humble submission, may not be the correct position of law. So it would then be for the state to first demonstrate before your lordships, my lords, that when this aspect of nomination was being considered by them, for their subjective satisfaction, my lords, these qualifications were present with these persons. That's my first argument, my lords. The second is, insofar as the Muslim members of the Bar Council are concerned, it cannot be randomly, my lords, I pick up X, Y, Z, whoever I feel appropriate. Because there is a criteria put in the proviso. It says senior Muslim advocate. It cannot be any A, B, C, D, my lords, because it concerns the management of all Muslim properties, my lords, in the state. The Waqf board has a very important role to play. So therefore, the requirement of law is that it has to be somebody who's senior. May not be, my lords, a member of the Bar Council, but maybe somebody with many years of experience. So therefore, they use the expression, my lords, senior Muslim advocate. So therefore, in the notification, what it says, because I don't have, my lords, how they have come before to this conclusion that these people are to be nominated, simply saying that the members of the Bar Association have decided to co-opt amongst themselves, my lords, may not be a proper procedure to be followed in this matter.
Well, okay.
That is, my lords, at page 23C.
There's no communication by the state to that effect.
There's nothing, my lords.
Nothing.
In the affidavit, it is absolutely silent. The notification says so, my lords, but the affidavit is absolutely silent. What steps were taken by them, my lords, for insofar as this category is concerned? There must be a process.
Exactly.
So if there is a process, my lords, they would have to point out before this honorable court what was the process. That, my lords, I think can be deciphered if the records are summoned. Yes. If the lordships call for the records, my lords, that will clarify this aspect. Highly obliged, my lords. Subject to what my friend said, then I'll respond.
I think we'll have to continue.
Post-lunch, man.
Post-lunch?
Well, I don't know. State would have to begin, right? Because I'm still submitting, my lords, that the records would be necessary.
This matter may be taken up next week, your lordship. I won't be able to assist the I don't have a brief and...
Lordship, if Lordship allows,
Mr. Kharmi,
if Lordship allows, I'll take less than 5 minutes just to read the act and the notification slowly at the end of which I'm highly confident Lordship will see there is no case of the petitioner. If Lordship indulges for 5 minutes, maybe we can finish the matter today itself, my lord. If Lordship allows. I'll just read the act and the notification. That is all.
You are so confident.
This is one of those rare cases when I'm confident, man. I'll just take 5 minutes, man. 5 minutes. My lord, going to the act first. Section 14, my lord.
Even then, the state has to.
Naturally, my lord, naturally. But at the end of my submissions, if Lordship still thinks state is still required to justify certain things, then definitely. My lord, Section 14. My friend has already touched upon this. There are two aspects, my lord. First aspect is that there are two kinds of members who can be part of the board. One are elected members and one are nominated members. If Lordship kindly looks at the Act, 14(1)(b), 14(1)(b), one and not more than two members as the state government may think fit to be elected from each of the electoral colleges consisting of so-and-so, so-and-so, so-and-so. And this is where the petitioner is putting a lot of focus on. But I submit, it's a misplaced focus. Anyway, so this is one category, elected members. If Lordship moves on, subsection C, one person so-and-so, 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 to be nominated by the state government. Similarly, D, one person from so-and-so to be nominated by the state government. E, one person from amongst Muslims to be nominated by the state government. So first point is, there are two kinds of members, elected members. If members are elected by the government under 14(1)(b), then naturally, obviously, they have to satisfy these criteria. But if they are nominated members under 14(1)(b) again, B or C, D or E, then maybe again criteria has to be followed. Point is, first point, that elected members and nominated members are the two categories of members. The concept of nominated members is there in subsection 3 also. Notwithstanding anything contained in this section, I'll just pause, my lord. The section starts with a non-obstante clause, and this is crucial in view of the last submission that petitioner had made. I'll explain that. But it's doesn't matter what is provided in the previous part of 14. Where the state government is satisfied, I'll pause again. First requirement is satisfaction of state government for reasons to be recorded in writing. Second requirement is state government has to record reasons, that it is not reasonably practicable to constitute an electoral college for any of the categories mentioned in subclauses 1 to 3 of subclause B of section 1. The state government may nominate such persons as the members of the board, as it deems fit. So the concept of nomination is in 3, number 1. Number 2, for a state government to exercise power under subsection 3, there are certain requirements. Satisfaction, where the state government is satisfied, for reasons to be recorded in writing. So government has to be satisfied, and you have to give the reasons in writing that it is not reasonably practicable to constitute an electoral college. In this particular case, in view of the situation existing in the case, in the state, I would say, state government was forced to exercise power under 3. In larger states, for example, my lord, UP, West Bengal, etc., you will find Muslim members of parliament. You will find Muslim members of the state legislature. You will find Muslim members of the bar council, etc., etc. But in a smaller state like ours, maybe it's not practical, it's not possible. So in that situation, invariably it happens that the state government exercises power under 14(3). In this case also, power has been exercised under 14(3). First, I draw Lordship's attention to the affidavit of the state, para 8. Para 8 of the affidavit. Just to ascertain under what have they exercised power. What is the stand of the state? Para 8, that is at page 4 of the affidavit.
Yes.
Para 8, that with regard to the averment made at paragraph 5 of the petition, the answering deponent would like to state that the provisions of section 14 of the Work Act have been followed, As at the time of notifying the Meghalaya State Waqf Board, Meghalaya State Waqf Board rules had not been notified yet, though it was under process. The provisions of Section 14(3) of the Waqf Act 1995 were relied upon and followed, which states the following. So very categorical stand state is taking that power under 14(3) has been exercised to notify the board, to issue that impugn notification. Now, what is 14(3)? I have already taken my lord through. The requirement is satisfaction of the state government to be recorded in writing. Now, whether this notification satisfies that requirement or not is what lordship is the only limited question that lordship will have to adjudicate upon. Now, I'll read this notification, but I will read it slowly, my lord, because it's important to read it slowly. Page 23 of the writ petition.
Yes.
Page 23. From the top, my lord. In exercise of the powers conferred by subsection 1 of section 13 of the Waqf Act, as amended, the Governor of Meghalaya is pleased to reconstitute the Meghalaya Board of Works with effect from the date of its publication in the official gazette. Whereas, now this portion, the second paragraph, whereas some of the members of the Meghalaya Board of Waqf to be appointed from amongst the Muslim MPs and Muslim MLAs, the Muslim Bar Council members and the mutwalis of certain works are to be elected by the electoral colleges of the respective categories. And whereas, A, there are no Muslim MPs or ex-MPs from the state. B, there are only 2 Muslim MLAs in the state assembly. C, the Muslim advocates of the Bar Association have, however, agreed to co-opt members from amongst them to be members of the Meghalaya Board of Waqf. And whereas the state government is thus satisfied. I'll just pause here, my lord. A, B, and C, what my friend has projected, what the petitioner has projected, is that they, especially C, it amounts to certain arrangements between members of the Bar Association, etc. I beg to differ, my lord. A, B, and C are reasons that the state government is giving, as required under 14(3), for reasons to be recorded in writing. These are the reasons that are being recorded in writing. Because there are no MPs, because there are only 2 MLAs, and because there are no senior members of the bar, but they are agreeing to co-opt amongst themselves, which I agree with my friend is not the prescribed procedure. Because of these reasons, what is the consequence? And whereas the state government is thus satisfied. Requirement under 14(3) was satisfaction of the state government to be recorded in writing, that it is not practicable to constitute the respective electoral colleges for the purposes envisages. This is important, my lord. Hence, resorted to the provisions of subsection 3 of section 14 of the aforesaid Act. Now, therefore, in exercise of the powers conferred under section so-and-so, the Governor of Meghalaya hereby nominates. All these are nominated members, my lord. Very clearly showing once again that this is the notification issued under 14(3) and only under 14(3). It is not a notification that makes any reference or draws any power from 14(1), where the requirements, criteria, etc. will come in definitely. This is a notification on the face of it being issued under 14(3). Going back to 14(3), the requirement is, as I pointed out, my lord, where the satisfaction of the state government to be recorded in writing. It does not say it has to be, there have to be good reasons. It has to be good satisfaction or anything of that sort. Reasonable reasons, I would submit, reasonable reasons are required. And what are reasonable reasons? The definition of reasonability is under the Wednesbury principles, my lord. So I'll place the law also regarding what does Wednesbury prescribe as far as reasonability is concerned. But the point is very simple, my lord. This is a notification very clearly and cannot be disputed that is issued under 14(3). To get around that, the petitioner has invoked, has submitted that possibly even if this is a notification under 14(3), the letter or the spirit of 14(1), where there are criteria prescribed, that has to be followed. My lord, no. The language of 14(3) does not require that. That's why I said it starts with a non-obstante clause, notwithstanding anything contained in the section, notwithstanding anything contained in 14(1). That means notwithstanding any of the qualifications or the criteria mentioned in 14(1), government has the, I would go so far as to say the free will or the free license, open license to constitute as it deems fit. So long as the check and balance which is there, so long as government is satisfied for reasons to be recorded in writing. Does the notification contain the reasons? Yes, it does. Are they valid reasons? Are they invalid reasons? Are they satisfactory reasons? I would submit, my lord, that lordship, that's a very subjective exercise, which, with respect, I have to point this, lordship may not go into. Only thing is, are they reasonable reasons? Wednesbury says that they are reasonable. So Wednesbury principle, my lord, I am reinventing the wheel out here, but what does United Commission. This is from 2003. If lordship kindly looks at para 7. Just to understand what is Wednesbury, the concept of reasonableness under the Wednesbury principle, and whether it applies to this notification. Para 7. Lord Green said in 1948, in the famous Wednesbury case, that when a statute gives discretion to an administrator to take a decision. Para 7, my lord. I'll read again, my lord. Para 7. Lord Green said in 1948, in the famous Wednesbury case, that when a statute gave discretion to an administrator to take a decision, I'll just pause, my lord. 14.3 gives discretion to the state government to take a decision. The scope of judicial review would remain limited. He said that interference was not permissible unless one or the other of the following conditions was satisfied, namely, the order was contrary to law, number 1, or relevant factors were not considered, number 2, or irrelevant factors were considered, or the decision was one which no reasonable person could have taken. Only in these 4 or 5 circumstances can judicial interference be allowed, my lord, when there is a discretion given to an administrator or the government in this case, my lord. I'll continue. These principles were consistently followed in UK and in India to judge the validity of administrative action. It is equally well known that in 1984, Lord Diplock in so-and-so versus so-and-so summarized the principles of judicial review of administrative action as based upon one or the other of the following, namely, illegality, procedural illegality, and irrationality. These are the only grounds or the situations in which a writ petition of this nature, challenging administrative action or a discretionary decision taken under 14.3 would lie. Very obviously, my lord, petitioner has not made out any such case. Any such ground has not been made out. So therefore, my lord, going back to the notification, the question again to be answered, I reiterate, is whether satisfaction of the state government is recorded in writing. The only requirement under 14.3. The reasons and the satisfaction is recorded there. These A, B, C are not other things, anything besides reasons to be recorded in writing. So state government is saying, because there are no Muslim MPs, because only 2 MLAs are there, because no members of the bar, they are adopting some co-opting procedure. Therefore, we are exercising power under 14.3. 14.3, if power is being exercised, qualifications, criteria, whether I am qualified, not qualified, etc., with respect, my lord, has no place. Has no place. It would have had a place if this was under 14.1, my lord. Under 14.1, definitely. 14.3, if the power is being exercised, it just so happens, my lord, that notification contains the qualifications of these various people. But that is neither here nor there. If the notification did not contain these qualifications also, being under 14.3, where no qualifications have been prescribed, it would have been a valid notification. Just for transparency, maybe they have put in these qualifications, etc., but not required also. Just to sum up, my lord. Clearly, evidently, this is a notification under 14.3. If it is a notification under 14.3, it has to satisfy the requirement of 14.3. What is the requirement of 14.3? The satisfaction of the government to be recorded in writing, that it is not possible to constitute a board under 14.1 from the electoral college, etc. That satisfaction is being recorded. So the requirement of 14.3 being satisfied, I submit that there cannot be any fault found with this particular notification. That's all.
I can just very quickly respond to what my friend is saying.
We'll continue with these. Let the
State come.
state comment.
There's only one reason what my friend is saying is correct. The moment we're invoking Wednesbury's, my lords, and your lordships are aware, there's a series of decisions. Discretion in India, my lords, is not absolute. Your lordships have held that in, my lords, Kitana of judgments, that if the statute even, my lords, even if it gives you discretion, that discretion is never absolute. And that is why, my lords, to examine whether...
We just have to see, we have to look at the criteria.
I agree. Discretion is never be exercised
cannot be absolute.
in an absolute vacuum. But the checks and balances, as I pointed out, is the requirement that the government puts down the reasons in writing. Reasons are there, my lord.
No, but merely putting reasons is not enough, my lords. They have to be valid reasons.
See, the main principle which sticks out is the reasonableness itself.
Absolutely. I'm obliged. I'm obliged.
There, you have to.
Which is why, my lords, we invoke Wednesbury's every time.
See, let's put it this way.
Yes.
What a layman would think.
Yes, ma'am.
It should not be such, my lords, that a prudent person applying his mind, my lords, would then do an act which any prudent person would not do.
Exactly.
That is one of the criteria that your lordships have now developed. We try to assist your lordships on the law also. Let Mr. Kharmi come, my lords, he can assist the state.
Yeah. Yes, Mr. Abraham, what do we do? When do we?
Next week, your lordship.
Can we have it on Monday, my lord, just to keep the matter fresh in my lords?
Not
If that is convenient.
Not on Monday.
Monday is a difficult day for me as well.
We'll have it on Tuesday then.
Tuesday.
Very quickly.
Tuesday, Mr. Paul.
Well, let's bear with me for a second. Tuesday, minutes.
Heard Mr. K. Paul, senior counsel for the petitioner. So heard Mr. S. Jindal, counsel for respondent. You are respondent?
5 to 8. 11, 10, 11, 12.
5 to
5 to 8.
5 to 8.
10, 11, 12.
5 to 8, comma 10, 11. Hearing will continue on the next date fix. As agreed to by the parties, this is matter for further hearing. This is matter on 17th.
Obliged.
Item number 10.
I think
We'll have it next week, madam.
2 weeks.
No other matter. Go to.
This is 2025 matter.
Yes, Your Lordship.
3 weeks then. Can you
You have to be
10?
before
3 weeks, okay? 10, 11?
Item number 11.
Yes. When do we have it?
Sir.
Sir, 11. Lordship,
11?
Lordship, may I
Who's
have
there? Who's? You're there?
Yes, your lordship.
2 weeks? 2 weeks.
much obliged.
Lordship, there is another item, that is item 2, bail matter. Kindly have this matter tomorrow, Your Lordship.
Your Lordship, if I pray on Monday, Lordship, tomorrow it will be with difficulty for me, Lordship.
Not on Monday.
Monday 16?
We'll have it on 19th.
19? Lordship, it's fine, Your Lordship.
On premier parties. This is better on 19th.
19. understand.